Afternoon. I'm Patricia Lee, Chair of the American Bar Association Standing Committee on Public Education, and it's my pleasure to welcome you to today's program entitled Civil Disagreements, Independent State Legislature Theory. This is the third in a series of moderated debates on current, critical, and often contentious civic questions sponsored by the American Bar Association Division for Public Education, the Chicago and Austin, Texas Lawyers chapters of the American Constitution Society, the Chicago chapter of the Federalist Society, and Reform for Illinois. Programs begin with a resolution, followed by a parliamentary-style debate with experts arguing for and against the resolution. After the debate, we will have a moderated discussion among the debaters and Q&A from the audience. Today's debate and discussion will address the independent state legislatures theory, a question currently before the Supreme Court in the voting rights case of Moore versus Harper, to determine whether state legislatures have exclusive power, not subject to federal or state courts, to govern all aspects of elections, electors, voting registration, and procedures. You can find debate materials linked in the chat, and please share any questions you may have in the Q&A at the bottom of your screen. Note that Illinois lawyers may receive CLE credit for this program. Simply watch for a follow-up email tomorrow with instructions. Thank you all for joining us today. Now I am pleased to introduce David Melton, board member of Reform for Illinois, who will moderate today's debate and discussion. David?
Thank you very much, Pat. It's my pleasure to be able to introduce our two panelists and for this debate today. And let me begin by just giving you the short bios. So John Yoo is the Emanuel Heller Professor of Law at the University of California, Berkeley. He's also a non-resident senior fellow at the American Enterprise Institute and a visiting fellow at the Hoover Institute and Stanford University. His 10th book, Defender-in-Chief, Trump's Fight for Presidential Power, was published by St. Martin's Press in 2020. Professor Yu's other books include Striking Power, How Cyber Robots and Space Weapons Change the Rules for War, Point of Attack, Preventive War, International Law and Global Warfare, and Crisis and Command, A History of Executive Power from George Washington to George Bush. Professor Yu has published more than 100 articles in academic journals on subjects including national security, constitutional law, international law, and the Supreme Court. He also regularly contributes to the editorial pages of the Wall Street Journal, the New York Times, Washington Post, Los Angeles Times, National Review, among others. Professor Yu has served in all three branches of government. He was an official in the U.S. Department of Justice, where he worked on national security and terrorism issues after the 9/11 attacks. He served as general counsel of the U.S. Senate Judiciary Committee. He has been a law clerk for Supreme Court Justice Clarence Thomas and Federal Appeals Judge Lawrence Silberman. He has been a visiting professor at Seoul National University in South Korea, the Interdisciplinary Center in Israel, Keio, pardon my pronunciation, University in Japan, Trento University in Italy, University of Chicago, and the Free University of Amsterdam. Professor Yu supervises the Public Law and Policy Program, the Korea Law Center, and the California Constitution Center. He also serves on the boards of the Pacific Legal Foundation, the Federalist Society's Separation of Powers and Federalism Division, the Universidad Científica del Sur Law School, and the Asia Pacific Law Institute at Seoul National University. He is winner of the Federalist Society's Paul Bater Award. Professor Yu graduated from Yale Law School and summa cum laude from Harvard undergraduate. Our other debater is Nicholas Stephanopolous. Nick's research and teaching interests include election law, constitutional law, administrative law, legislation, and comparative law. His work is particularly focused on the intersection of democratic theory, empirical political science, and the American electoral system. His academic articles have appeared in, among others, the California Law Review, the Columbia Law Review, Duke Law Review, Harvard Law Review, Northwestern Law Review, New York University Law Review, Stanford Law Review, University of Chicago Law Review, University of Pennsylvania Law Review, Virginia Law Review, and the Yale Law Journal. He has also written for popular publications, including the New York Times, the Washington Post, Los Angeles Times, Chicago Tribune, Atlantic, New Republic, Slate, and Vox. He has been involved in several litigation efforts, as well as including two partisan gerrymandering cases. based on his scholarship and decided by the Supreme Court. Before joining the Harvard Law School faculty, Mr. Stephanopolous was a professor of law at the University of Chicago Law School. He was previously an associate in law at Columbia Law School and associate in the Washington, D.C. office of Jenner and Block. Before entering private practice, he clerked for Judge Raymond C. Fisher of the Ninth Circuit Court of Appeals. A graduate of Yale Law School, Mr. Stephanopolous holds a Master's of Philosophy and European Studies from Cambridge University and an AB in Government from Harvard College, graduating summa cum laude. While at Yale Law School, he served as editor-in-chief of the Yale Journal of International Law, received the Jewel Prize for best second-year student contribution to a law journal, and was a finalist in both the moot court and mock trial competitions. Nick is a frequent television and radio commentator on legal issues. He is a co-founder of Plan Score, a website evaluating past, present, and proposed district plans. He is a member of policy reform institutes, including Campaign Legal Center's Litigation Strategy Council and the Committee for the Study of Digital Platforms. He has been named to the Political 50 list, as well as the National Law Journal Chicago's 40 Under 40. So with those introductions, let me just inform the audience that the way this is structured, what we will do today is we will begin with a presentation by Professor Yu speaking in favor of the independent state legislature doctrine. He will have 13 minutes opening and 2 minutes for rebuttal. Then Professor Stephanopolous will go. He will have 13 minutes for opening and 2 minutes for rebuttal as well. That half-hour debate will then be followed by a moderated discussion in which I will pose some questions and seek some answers from both our panelists. And then we'll finish up with a final 15 minutes of questions and answers from the audience. So that's the overall structure today. And with that introduction, I look forward to turning the floor over to Professor Yu for your opening statement.
Very good. Thank you, David. I'd like to thank the ABA, the ACS, Federal Society, and was it Reform Chicago was the other
Reform
entity?
Illinois and Federal
Reform
Society,
Illinois,
Chicago.
Usually the same thing. I'll just say, I don't think we have Reform California. We've given up on that one. So thank you very much for inviting me to join you. I have to pause. Our timer's not working, is it? But I don't want to take any undue time, but I'll start.
I
anyway.
think you're okay. I think it might take just
Okay.
a second to kick in.
Okay. I just want to say how much I welcome the opportunity to debate with Professor Stephanopolous, and to say he is one of our country's top election law experts. I coming to this more as someone who studies constitutional interpretation and focuses more on the structural issues on the Constitution rather than the taking and counting and litigation over votes and over elections. So I look very much forward to hearing his comments and arguments. So all of you probably know this is the issue that's squarely before the court in Moore versus Harper, which asks the court to review whether a body other than the state legislature, and in this case, the North Carolina state courts, can review a redistricting map and make changes to it. This, of course, has gotten heightened interest, I think, not just because of the redistricting that occurs every 10 years because of the census, but because many people think the provision is analogous to the one for the selection of presidential electors. As you know, the Constitution also settles on the state legislatures to prescribe the manner of selecting the electors for president. I also have to say, I think if this case were decided, or this issue were decided solely on precedent, it seems to me that the argument in favor of allowing the North Carolina Supreme Court or any other entity selected by the state constitution to review redistricting maps would prevail because of a case called Arizona State Legislature, which was decided several years ago with a majority opinion written by Justice Ginsburg, which found that Arizona could delegate the process of drawing congressional districts to an independent redistricting committee. We have a similar system here in California as well. However, I'm going to make arguments that Arizona state legislature was wrong. If we were to, I think, play the chess game of whether precedent would be overturned, I would only point out that Chief Justice Roberts wrote the dissent in that case. Justice Kennedy wrote the majority opinion. I think all of the justices who were in that, maybe all but one of the justices in the majority opinion are not on the court anymore. I think a lot of court watchers after the oral argument in Moore versus Harper suspect or guessed that the court would actually side with the state legislature. I could be wrong, it's hard to predict. And also just one other point, it seems now that that case, the granting of cert there might be vacated because there's been an election and a new state Supreme Court has reversed the earlier Supreme Court and I believe allowed the state legislatures redistricting to proceed. And so it might be the case that this case no longer, that case is now in a way moot. Let me start with the text. And I just want to take the sources in the way I think a common sense interpreter of the Constitution would, or a judge might on this, or a justice on the Supreme Court. Take a look at Article 1, Section 4. It says the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. But the Congress may at any time, by law, make or alter such regulations, except as to the places of choosing senators. It seems to me, if we just take the plain text of the Constitution at face value, it identifies an institution of a state, the legislature, right, to regulate the time, places, and manner of elections, which time, places, and manners we've always taken to mean to include redistricting. If, as the argument goes, the people of a state through a constitution could delegate the power to draw districts elsewhere, why use the word legislature? Why couldn't the founders have just used the phrase the state? Right? Doesn't have to pick any particular institution of the state. Let the people of the state decide. Justice Ginsburg, in her opinion, basically said that the legislature means the supreme legislative power of the state, which would include, therefore, the state constitution or things adopted by popular referenda and initiative, as was the case in Arizona and in California. However, I think that flies smack into the constitutional text, again, because the constitutional text identifies a specific institution of a state government rather than the state in general. This is, I think, a pretty easy thing for the founders to have done. In fact, several times throughout the constitutional text, our founders make distinctions between a state as an entity, state legislatures, state executives, and state judiciaries. You could look elsewhere in Article 1. You could look at the very first sentences of Article 1, which talk about, right, vesting the legislative power in Congress, which talks about there's a legislative power and then there's an institution of a legislature. You could look right before Article 1, Section 4 at Article 1, Section 3, which says that the state legislature selects senators. Now, of course, that was that was amended by the 17th Amendment to allow for popular election. As Chief Justice Roberts said in his dissent in Arizona state legislature, if it were possible for a state constitution to just delegate the federal functions given to the legislatures to somebody outside the legislature, or just to create new entities and just title them all legislatures, then why bother with the 17th Amendment? Right? Why actually go to the trouble of amending the Constitution and say, instead of state legislatures picking senators, it'll be by popular election. Each state could have just done that for itself. I just know this is Chief Justice Roberts often has a pithy line, and he questions whether this could have been the case. And then he says, "Wow, the 17th Amendment's founders," he says, "what chumps they must have been to not have fully grasped the opinion that the majority set forth in Arizona state legislature and gone to the trouble of amending the Constitution rather than just simply changing their state constitutions." If you go through the Constitution, it actually, I believe, specifically distinguishes state legislatures 17 different times. I think under the idea that states were free to create entities that could accept delegated legislative power that didn't have to be legislatures themselves. Again, why bother those 17 times? Why not just say the state in each of those instances? And to take the argument one step further, why would this power of a state, to move around all the bodies of the state legislature, all the powers of the state legislature, break them up, divide them, create new entities, delegate them to different bodies, stop at commissions, or stop with the legislative power? With this argument that the majority set forth in our Arizona state legislature also mean that a state could move around the executive power or the judicial power of the state. For example, as we all know, the Supremacy Clause requires that state judges give precedence to federal law over state law. Could a state just simply do away with its state court system and create a body with things that look like executive officers, single members, or maybe just one body to exercise the judicial power of the state? Would they really be courts in the sense we understood them? Also, the federal Constitution refers to state executives. Could those powers be transferred to courts? Could they be transferred to legislatures? It's hard for me to see what the limiting principle is of the argument that states are just fully free to rearrange their governments as they see fit for the purposes of carrying out federal functions. And I want to cabin my argument to make clear, I'm not saying that the federal Constitution places a straitjacket on states and how they organize their governments. I think states are fully free to create all kinds of bodies. Let me tell you, in California, we got all kinds of things here which have no semblance to the federal Constitution. For example, we have mass transit authorities of their own governments with their own armed police forces, which don't seem to be under the control of any of the counties or cities they're located in. I'm not saying that states are not allowed to be innovative and creative in carrying out state functions. It just seems to me that when it comes time to carrying out federal functions, in a sense, in areas where the federal Constitution commandeers, as it were, state institutions for specific purposes, it's almost as if the bodies, those parts of the state government, become part of the federal government for those select functions. There, I think the Constitution does limit the ability of states to create, for state constitutions to just be endlessly malleable. Now, why does that make sense? I would point to another case that didn't get talked about as much in this whole debate, which is the federal term limits case back from the mid-90s. This is a case called U.S. Term Limits versus Thornton. And in that case, the court said that states could not take their power over the holding of elections. They could not take their power to control the ballot and how it appears, to impose term limits. And in part, in that case, the court said, those people, when they're being selected, they're federal officers. The states in those cases are participating in a federal function. And when they do so, the Constitution does place some limits on how states can carry out that federal function. In that situation, the court said states could not create term limits because the federal Constitution itself did not have term limits for members of the House and the Senate. I think similarly here, if you go back and look at the court's cases on commandeering, in general, the court does not permit the federal government to take over or commandeer state governments. But in those cases, the cases are called New York versus United States and a case called Prince, the court does say when the constitutional text does single out state institutions, those sometimes can be commandeered. In the Prince case, Justice Scalia specifically looked at the fact that state courts are, in a sense, commandeered to perform federal functions, because the Constitution does permit the possibility of a world where there are no lower federal courts, just state courts, and then a U.S. Supreme Court. In that case, state courts are performing a federal function in a way they're almost commandeered by the federal government, should Congress choose not to create any lower federal courts. So just to wrap up, I got a little bit of a head start because the timer dancer, so I'll try to end a little bit early to take that into account. I think the argument primarily in favor of control of redistricting by state legislature rests on the text and the structure of the Constitution. I didn't even get to the founding evidence. I could go through some of that, but I think it's fair to say that our founders really never conceived of the possibility of creating these kinds of institutions that are not state legislatures of the kind that they were accustomed to. Constitutional text specifically identifies legislatures as an institution that is responsible for conducting elections, including the drawing of districts. I think this makes sense in terms of the constitutional structure when you see that the founders repeatedly identified different state institutions like judges, legislatures, and courts. So thanks very much, and I look forward to Professor Stephanopoulos' response.
Thank you very much, Professor Yu. To account for the timer snafu at the beginning, we'll give Professor Stephanopoulos an additional 30 seconds at the end of his presentation, of his opening statement. Professor Stephanopoulos, the floor is yours.
Terrific. Thanks very much, David, for moderating this event, also for your gracious introduction earlier. Thanks to all the organizers as well, and to Professor Yu for his very clear and I think quite substantively reasonable remarks, much as I happen to disagree with them. It's also great to be speaking to this audience of Chicago lawyers. I used to live in Chicago for many years, and so it's nice to stay connected to my old home. So I'll be arguing today that the independent state legislature, or ISL theory, should not be adopted. And I think that under the usual modalities of constitutional interpretation, this is quite an easy call. There's only one modality, textualism, which even arguably supports the ISL theory. In my view, every other conventional mode of constitutional argument points the other way. There's a different plausible reading of the relevant constitutional text. The history points the other way, so does precedent, and so does consideration of what the consequences would be of adopting the ISL theory. And so I'll spend my time now going through these different forms of constitutional argument, aided hopefully by some slides that I prepared. So let me start with the constitutional text. As Professor Yu mentioned, there is one plausible textual argument in favor of the ISL theory. This is the argument that legislature means just the state legislature, free from, divorced from all other state actors and from all other constraints. The key point to realize here, I think, is that this is not the only reasonable reading of the term legislature. Another equally plausible reading of the term is that legislature means the whole lawmaking system or process that's created by the state constitution. If you look at various founding era dictionaries, this seems to be the reading that they contemplate. They define legislature as the power that makes laws, which can be a reference to the entire state lawmaking process. And many of the remarks of framers like George Mason, James Iredell, are also consistent with this reading. These and other framers often referred to state legislatures as creatures of the state constitutions that created those bodies. And some more support for this more generous reading of legislature comes from what you might call the congressional analogy. So the Constitution often refers to Congress, and when the Constitution does so, it usually doesn't mean Congress alone, divorced from the other branches of the federal government. Instead, most constitutional references to Congress mean Congress with the consent of the president as subject to judicial review by the federal courts. And by the same token, it's very easy to see a definition of legislature, meaning legislature with the consent of the government, subject to judicial review as set forth in the state constitution. So I think the text is somewhat inconclusive because there are reasonable definitions pointing both for and against the adoption of the ISL theory. Every other modality, though, I think really does point firmly against this theory. Let me start with history. So before the Constitution was ratified under the Articles of Confederation, there was a provision almost identical to the Elections Clause. This provision said that delegates to the Confederation Congress, quote, shall be appointed in such manner as the legislature of each state shall direct. Despite this language, essentially every state constitution under the Articles of Confederation regulated the appointment of delegates to the Confederation Congress. And so therefore, this language was not understood to give state legislatures plenary power over the appointment of congressional delegates. It's the exact same story after the ratification of the Constitution. Almost all state constitutions in the decades after ratification regulated congressional elections. And that means that, again, the Elections Clause was not understood to give state legislatures plenary power over congressional elections. If it were, we wouldn't have seen all of these state constitutional provisions regulating congressional elections. So I think there's an almost uniform pattern of historical practice that cuts against the ISL theory. Turning to Supreme Court precedent, if anything, it's even more monolithic than the history of state practice before and after the ratification of the Constitution. So for about 100 years, the Supreme Court has consistently, uniformly rejected the adoption of ISL theory. The first key case was Hildebrandt in 1916, where the court said that state legislatures' regulations of congressional elections can be constrained by popular referenda when such referenda are authorized by state constitutions. A few years after Hildebrandt, in the Smiley case in 1932, the court said that state legislatures can also be constrained in regulating congressional elections by gubernatorial vetoes authorized by state constitutions. And then just a few years back, as Professor Yu alluded, in a case out of Arizona, the Supreme Court said that state legislatures can also be constrained by voter initiatives when such initiatives are authorized by state constitutions, and even when such initiatives fully transfer regulatory authority over congressional elections to independent bodies like commissions. So together we have essentially a century of uniform precedent, making it quite clear that state legislatures' authority to regulate congressional elections can be constrained in all sorts of ways by state constitutions. And I think it's indisputable that for the court to now embrace ISL theory in more or some other case, the court would have to turn its back on this century of uniform precedent pointing the other way. Let me turn next to some practical consequences that would follow if the court, in fact, did reverse this century worth of precedent. So one negative consequence would be the need for dual rather than unitary electoral systems in every state. So there would be federal elections that would be run the way solely the state legislature wants to run them. And there would also be all other elections in a state, state and local elections that would be run under a process established by the whole state lawmaking system. And this would obviously be a mess, very, very difficult for states to administer, very confusing for voters, and very different from how states have always run their elections, which has been in a unitary fashion. Another negative consequence of adopting the ISL theory would be never-ending federal litigation over which state electoral rules are valid and which ones are not. This litigation would often take place on the eve of elections, which is the last time that you want complicated federal lawsuits unfolding. All of this federal litigation over state electoral rules would run strongly counter to the current court's preference for federal courts not to be involved in electoral minutia. And this kind of extensive federal court involvement in state elections would also be a serious affront to federalism, one of whose pillars is that states get to decide how to run their own electoral systems. So these practical consequences are bad enough. The implications for democracy, if the ISL theory were adopted, are even worse in my view. And this is because state legislatures are really the very last actors that we would want to be in charge of congressional elections. State legislatures are frequently gerrymandered, as in North Carolina and as in many other states. They're often even counter-majoritarian bodies where a minority of the public has managed to seize control of the majority of state legislative seats. Yet the ISL theory would mean that the very last actors we should want to be in charge of congressional elections would be the only state actors permitted to regulate congressional elections. So governors elected statewide, not through gerrymandered districts, state courts were constrained by state law, officials with real expertise in administering elections, the people themselves, the ultimate source of sovereignty in our system, all of those non-legislative actors would be cut out of the regulation of elections by the ISL theory. And often gerrymandered counter-majoritarian state legislatures would be the only state actors with any say over how federal elections are run. For an example, just take the facts of Moore versus Harper itself. In Moore, North Carolina's highly partisan state legislature wanted to impose a brutal gerrymander that would elect 10 Republicans and 4 Democrats. Instead, the state Supreme Court approved a extremely fair and balanced map electing 7 Democrats and 7 Republicans. Had the ISL theory been in operation, though, the legislature's biased anti-democratic map would have been necessarily adopted over the court's fair and pro-democratic map. The last point I'll make very quickly is that all of this discussion about the ISL theory is arguably beside the point in the specific context of congressional redistricting. And that's because everyone agrees that no matter how you define state legislature, Congress can always step in and make or alter state level regulations. And arguably, Congress has done exactly that through 2 U.S.C. 2C. Last very quick thing, this statute requires states to establish by law the proper number of congressional districts for the state. And the court has told us that by law encompasses judicial decisions, including state court decisions. And so arguably here, there's no space for this debate that we're having because it's been superseded by this particular exercise of Congress's Elections Clause authority. Apologies for going over time, and I'll stop there. Thanks very much.
Thank you. Actually, you're just on time, Nick.
Oh, great.
So let me thank both John and Nick for those very thorough and interesting discussions. And let me go on. Let's go on to the second phase now. Well, I'm sorry. I'm forgetting the rebuttal statements. John, you've got 2 minutes for rebuttal, and then Nick, you will have 2 minutes for rebuttal.
Great. Thanks. This is very interesting. I think it's a good way to put it, as Professor Stephanopolous did, that one way to understand the difference here is between does state legislature mean a process, or just essentially the lawmaking process, or does state legislature mean an institution, which is what I argued in favor of. And you could ask, well, why would the founders pick an institution rather than a process? And in part, I think it's because the founders, if you look at the founding evidence, thought that the state legislature would be the truest representative, not of the passing interests of the voters of the state at that time, but the interests of states. Every time they pick state legislatures, they're trying to shore up or promote federalism as a structure, which they understood would be different from time to time between what the voters of a state might want to do. In fact, as we've seen in our history, there may be times when the voters of a state might want to give up power of their state as an institution. So let me say point out some potential implications of this argument. I think one of the most important places where the Constitution identifies state legislatures is Article 5, the approval of constitutional amendments. As you know, the constitutional amendments have to be approved by 3/4 of the state legislatures, as the text says. As I understand Professor Stephanopoulos' argument, or at least the argument of the Supreme Court in North Carolina, a state governor could veto, right, the ratification of a constitutional amendment by his or her state. A state court could block the ratification of a constitutional amendment. Could a state court even order that a state ratify a constitutional amendment because it thinks the state constitution might require it? Once you start to say it's just the legislative process, again, what is the limiting principle? Oh, my time's already over. Geez, that was fast. Sorry. I had a whole lot of points to get to, but hopefully they'll come out in the question and answers.
Thank you. Nick?
Great, thanks. I'll try to make a couple of very quick points. One is that the framers were no fan of state legislatures. They were deeply suspicious of state legislatures for many reasons that have come to fruition in the years since the framing. Madison and other framers were of the view that state legislatures were fickle, subject to capture by particular factions, often undemocratic. And so they certainly shared the view that I outlined, that it would be foolish to give these potentially undemocratic bodies such power over elections. The second point is that I think Professor Yu makes a good point about the absence of a limiting principle in the position that I've outlined. It's true that there's no legal limiting principle, on my view, to how state constitutions could organize the regulation of congressional elections. But I think, as in many other constitutional domains, politics can supply the limiting principle. Why won't state constitutions delegate the regulation of congressional elections to me or to Vladimir Putin? Politics. You don't necessarily need a constitutional legal check when you have a perfectly good political check to those kinds of outlandish structures for regulating congressional elections. The last thing is, why are we having this conversation now? It's always vexed me that we've had the federal Constitution for more than 200 years. Ever since the founding, we've had non-legislative state actors involved in regulating congressional elections. So why on earth is the ISL theory emerging as a hot button issue today? I think there are concerning answers that it's only now that the ISL theory would potentially result in clear partisan and ideological consequences. And if that's the reason why we're now having this debate, that really worries me. I'll stop there.
Thank you very much again, both of you, again, for those very thorough and interesting discussions. Let me turn your attention to a side issue, potentially, that Professor Yu referred to during his presentation. After this case was fully briefed and argued in the Supreme Court, the situation giving rise to a change during the November 2022 elections. Republicans in North Carolina picked up 2 seats on the North Carolina Supreme Court, flipping the majority from a Democratic to a Republican majority. That court subsequently decided to rehear its 2022 redistricting decision, and it reheard the case in March of this year. In April, it overturned that case, and presumably it will be going back to the Republican map that Professor Stephanopolous referred to in his presentation. The Supreme Court, the U.S. Supreme Court, subsequently asked for additional briefing as to its ability to decide this case in light of the North Carolina Supreme Court's rehearing and vacating of its earlier ruling. 2 sets of litigants in the U.S. Supreme Court. The North Carolina Republican legislators who filed the case, as well as Common Cause, which was an intervener, have urged the U.S. Supreme Court to still decide the case on its merits, saying that the authority of state Supreme Courts to review legislatively drawn maps remains a pending and legitimate issue and is likely to recur. The Biden administration and several other litigants in the case have questioned in the U.S. Supreme Court whether there still exists a final judgment in North Carolina for the U.S. Supreme Court to address. So, John and Nick, let me ask you both. We'll start with John and go to Nick. How do you think the Supreme Court is actually going to handle those most recent developments in terms of whether it will reach the merits or whether it will dismiss this case for want of a final judgment in North Carolina?
David, I don't know whether you want us to have our camera on throughout the discussion and Q&A.
It's up to you, John, but I would say probably leave it on during the leave it on during this period.
I'll take a first take on this. I bet that the court will dismiss the case, but I'm not sure. But it seems to me that if you want to see how this case in a way fits in with the court's, I think it's a broader agenda, particularly on the part of Chief Justice Roberts in these kinds of cases, is to gradually pull the court out of its past involvement in election law. I think that's why it kind of makes sense, along with this Rucho case where the court said we're also not going to adjudicate redistricting claims because it's a political question. What I found remarkable about that case, and a sign of how badly the court wants to get out of this area, is that it revitalized what people call the second part of the political question doctrine, which had not been really used in a very, very long time. If you may remember, the political question doctrine usually, as the court has used it, is to say if the Constitution actually gives a decision to another entity and sort of divests the court of power, say with the impeachment clauses, then there's a political question, we won't decide it. Here, the court relied on the second part of the political question doctrine, which is mostly laid out in Baker versus Carr, where the court didn't apply it, which was almost to say, this is too hard, right? We can't find a judicially manageable standard. So I would expect the court would pull out of Moore versus Harper as well, but I could be wrong. The second point I just like to make about Moore versus Harper and the events you outlined in the elections in North Carolina is Professor Stephanopolous, I think rightly identified a lot of the problems with state legislatures these days and at the time of the founding. But I wonder whether, given what we saw in North Carolina itself, where you saw a switch in the court and its membership leading to a quick switch in the decision of the lower court below. You guys are a lot closer than me to the Wisconsin court elections, where you saw a lot of money pouring into an election. It did seem rather partisan. Don't state courts now, especially since I think 3/4, is that about right? 3/4 of the states elect their judiciaries. Are state courts really immune from the same problems that Professor Stephanopolous identified with state legislatures? Even couldn't they actually be worse, since the number of people, the number of seats you would have to change to achieve your objectives is a lot smaller if you try to, as it were, take over a state Supreme Court rather than a state legislature, which is usually just larger in number, more diffuse, more attached to local interests. So it'd be a lot harder, I think, that the concentration of power in state Supreme Courts. Gosh, it seems to me that a lot of these same problems with potential corruption, potential abuse, just the results of partisan electioneering are going to be, or becoming just as bad, or could become just as bad with state courts as well. And I think what's happening below in Moore versus Harper sort of illustrates that.
Okay, Nick?
Yes, I haven't followed the ins and outs of exactly what the arguments are for deciding Moore versus not deciding. I've skimmed some of the briefs, and like Professor Yu, I also think it's quite likely that the court will ultimately not reach the merits in this case. Couple of thoughts. One is that even if Moore doesn't address the merits of the ISL theory, there are plenty of other vehicles these days that raise almost the same issues. For example, in Ohio, the Ohio Supreme Court under the Ohio Constitution has also repeatedly struck down congressional maps for that state. And I believe there's a pending petition raising the ISL issue from Ohio in front of the court. I will say it would be very, very nice when the court reaches the ISL issue if it were to do it in a case that didn't present the usual partisan and ideological lineups in these cases. I would love to see a Democratic legislature doing something untoward, and a governor or a conservative state court blocking that anti-democratic abuse by a Democratic legislature, and the court dealing with the ISL theory in that context. There are so many suspicions of the court, of the Supreme Court in this context, and it would help a lot to allay those misgivings if the court were to embrace the ISL theory in a context where it wasn't a Republican gerrymander that ends up being the result of the Supreme Court's intervention. Couple other quick thoughts just in response to Professor Yu's remarks a minute ago. I completely agree that state courts, elected state courts, are full of their own problems. Nobody loves the idea of one or two seats changing hands and that resulting in a 180-degree reversal in a court's jurisprudence. As we just saw in North Carolina and are very likely to see the other way in Wisconsin. That's why for people like me who oppose gerrymandering and other anti-democratic abuses, state courts are a plan C or a plan D. They're not plan A. I'd much prefer taking this activity out of the hands of legislators altogether. And so if states can do that on their own through the adoption of commissions, great. far, far better for Congress just to require it. That would be a single uniform step for the whole country that would just end self-interested redistricting once and for all. That's how every other country that uses single-member districts has solved the problem of gerrymandering. They haven't relied on a million heterogeneous state ports to solve the problem. They've just taken away redistricting authority from legislators. And so I think I would far prefer that as a solution to just an indefinite number of cases like Moore v. Harper popping up around the country.
Thank you. Let me see if I can drill down a little bit on where, John in particular, where you would draw the line in terms of the independence or the total power unrestricted of state legislatures under the independent state legislature theory, where that power would be subject still to some limits, if any. So first, let me start with the question, could other provisions in the federal constitution, such as the supremacy clause, basically override the power of state legislatures under the elections clause?
I guess I have to concede, it doesn't seem to me the Constitution imposes restrictions, by name on how state legislatures use their power, although I think they're still subject to the Bill of Rights and the Reconstruction Amendments. So I think, for example, suppose a state legislature, draws its districts, it still can't violate the Voting Rights Act. It still can't violate the 14th Amendment. I don't think anybody on the side of the North Carolina legislature is taking that extreme of view, right? That, and it seems the text of the 14th Amendment makes clear, it just applies to everything a state does.
Right. What about state constitutions? Do you think they could, for example, by giving governors the right to veto plans, is that something that the federal elections clause precludes?
That, I think, is the problem, because I think that's essentially what's happened here. You could say in the North Carolina case itself, if you look at the decision below, essentially the state courts didn't just say we get to, as an institution, decide what districting maps are going to be. They said you're violating the state constitution. It's not a state constitutional provision that was really on redistricting. I think Professor Stephanopolous follows this much more closely than I, but when I looked at the opinion below, I was a little surprised that the court below basically said this violates something along the lines of the state requires there to be free and fair elections. And so the court took that phrase, basically, it's almost like the Republican guarantee clause, it seemed to me, and say that allows us to get them up. But still, the North Carolina Supreme Court didn't say we're taking the powers of the institution. We're enforcing the state constitution. But to go farther, I wonder, could, if you took the opposite view and you do allow the state constitution to control how legislature picks, could the state constitution not just create another alternate institution, but could it actually draw pre-existing principles on redistricting or anything else having to do with the time, place, and manner of elections, and basically take most of it away from the hands of the state legislature? Because I think that's an implication of the other view.
Nick, you want to respond to that?
Yeah, my view is that it's commendable when state constitutions impose limits on the line drawing discretion of state legislators, because I very often don't trust state legislators with that authority. And so when there are constraints that say that you can't pursue partisan advantage, you must provide minority representation, you must comply with traditional criteria, I think those are all commendable constraints on a process that otherwise has the real potential to subvert a whole host of democratic values.
What about John's point that I think it was a clause in the North Carolina Constitution that said free and fair elections, as well as they relied on a couple of other due process and equal protection clauses as well. But I think it was mainly the free and fair elections clause. What do you think about John's point that that's really too amorphous a standard to generate consistent judicial resolutions?
Yeah, it seems to me that it is utterly conventional and commonplace for broad constitutional provisions to have particular concrete applications. At the federal level, the Equal Protection Clause is exactly as general and as amorphous as the state constitutional equivalents in North Carolina. And yet the US Supreme Court identified a one-person, one-vote rule in the Equal Protection Clause. The US Supreme Court identified a prohibition on racial vote dilution and racial gerrymandering in that same clause. And so if the Equal Protection Clause can have all sorts of applications to redistricting, I don't see why provisions written at an identical level of generality in state constitutions can't also have applications to redistricting.
Okay.
Well, David, can I throw in an additional point? It's not really a response to Professor Stephanopoulos, but something else that may help illuminate why the court is involved here, where it's going. But it does involve something I think Professor Stephanopoulos is arguing implicitly, is that I take it that Professor Stephanopoulos thinks that there's like a better versus worse kind of redistricting map, that it can be evaluated objectively by experts pretty much. Whereas I think the court, and I think this is sort of in line with, I think, what a lot of scholars think is that we can objectively evaluate through expert opinion in a way which maps are better or worse. That may be true or not. I think, and this is again going why it's the state legislatures, but also why the court's trying to pull out of these areas, is I think this is a court, it's not just in this area, but other areas that's becoming very sort of suspicious is too strong a word, but isn't so deferential to expert opinion anymore. This court might be one that sort of just give it all to politics. It's too messy. We tried to intervene, use more expert opinion, evaluate redistricting. And I think Chief Justice Roberts, if he's the one who dissented in Arizona State Legislature, he's the one who wrote about political question doctrine redistricting. Even though he's a justice who came up through Washington, D.C. and sort of is, if anyone were the representation of elite expert opinion in the judiciary. But I think he's leading the court away from deference to experts. And I think that's kind of what's going on in a bigger way here when you connect it to what the court's doing with the administrative state. And, we're seeing this case of Chevron doctrine, this major questions doctrine over and over again now.
Yeah, I think that's an accurate summary, John, but let me ask you this follow-up question and I'll ask Nick to comment. Doesn't that run a serious risk of saying that the court is not in the business anymore of defending democracy? It certainly does not seem to be interested in defending the Baker versus Carr decision from the 60s of basically one person, one vote.
Yeah, I actually think the court would say, or Chief Justice Roberts would say, the Supreme Court's job is not to defend democracy. It's to apply the constitutional text. And the constitutional text is often anti-democratic. No, I mean, that's true. Many features of the Constitution are anti-democratic.
Do you think that might actually result in a revival of a debate about what the clause in the Constitution that guarantees will remain a republic, whether that has any meaning?
Well, this is interesting. In a debate I've had on this subject with someone else, that's what my opponent, and I thought this was scurrilous, but he retreated back to the Republican Guarantee Clause and said, well, the judiciary would still enforce the Republican Guarantee Clause. And I was like, when have they ever done that? That is the refuge of scoundrels to say all problems are solved by the Republican Guarantee Clause. So no, I don't. In fact, I think if this is a court pulling out of politics, starting to expand the political question doctrine, I'm surprised they've done it. But I think one place they will, continue to stop, continue to resist intervention is in Republican guarantee of state governments.
Does that concern you at all insofar as it seems to resemble what the court did after Reconstruction when it basically turned its back on the 14th Amendment and allowed all kinds of Jim Crow laws and anti-democratic voting laws to remain in place for 100 years.
I don't. I mean, I think that the 14th and 15th Amendments take care of the problems with the Jim Crow period. I think the court was wrong in the way they interpreted the amendments in the post-Reconstruction period. I don't think that saying that the state legislatures will perform this function would lead us to a return to pre-Baker versus Carr days. I mean, I don't see any willingness on this on this court to. I mean, they struck down one part of the Voting Rights Act of 1965, but the court said we found this an extreme measure. The freezing in place of all the electoral systems and basically the former Confederacy. Again, I think it's the court, though, I think wants to provide a broader arena for politics to resolve these problems, and feels like I think the court feels like it overextended itself in trying to police democracy, as it were, as he said.
Right.
Can I say a couple of words on that?
Since John and I have dominated this, Nick, I will give you the last word in this portion of the conversation.
Great. Just a few points. One is that I really don't agree with the framing of this ISL case as one that has the potential to reduce federal judicial involvement in electoral disputes. Rucho, as wrong as I think Rucho was that kind of case. So, okay, after Rucho, federal courts are no longer involved in policing partisan gerrymandering around the country. Fine. If more comes out in favor of embracing the ISL theory, that results in dramatic new involvement by federal courts in electoral disputes around the country. Plaintiffs are going to go to town suing over one after another non-legislative state level electoral regulation of congressional elections. There are countless state court decisions, gubernatorial vetoes, voter initiatives, state constitutional provisions, all having to do with congressional elections. And so far from reducing the federal judicial role in elections, the ISL theory would supercharge the federal judicial role. Now, it's true that one thing the ISL theory would do is reduce the role of state courts under state constitutions in policing abuses when it comes to congressional elections. But that's just not the business of the US Supreme Court. Like, the US Supreme Court may not want federal courts to be involved in this area, and I think that's wrong-headed and runs directly counter to the brilliant insights of Caroline Product, which served the country well for a very long time. But that's neither here nor there. Nothing gives the US Supreme Court any say over what involvement state courts are going to have under state constitutions. And so, John Roberts may not like it when a state court decides a case about partisan gerrymandering under the state constitution, but it ought to be none of his business. And the idea that we're going to be reducing federal court involvement here, I just think is exactly backwards. There would be a surge in federal court involvement in electoral disputes of the like that we haven't seen in a very long time if a strong form of the ISL theory gets adopted.
And if we go back, I'll just throw out one last question, then we'll open it up to the audience's questions. If we do, if the Supreme Court were to rule on the merits here and uphold the ISL theory, that would mean that North Carolina would go back to that gerrymandered map rather than the map that the North Carolina Supreme Court imposed. Is that right?
Well, it wouldn't matter because the North Carolina Supreme Court, under its new composition, has already tossed out the fair map and given the state legislature the green light to go and draft a new map. So it seems clear that no matter what happens in Moore v. Harper, we're going to have a brutal anti-democratic gerrymander in North Carolina. in place for the next election.
Right, which brings us back to the question of, is this good for democracy? So John, let me throw this back to you. In a state where you've got basically a 50-50 split in the population and partisan votes, which is true in both North Carolina and Wisconsin, is it a good thing to allow such a gerrymandered map to exist where 50% of the population gets what was it, 8 representatives versus 2, and I'm not sure what it is in Wisconsin, but is that a good result for our country from a policy standpoint, do you think?
So I have intuitions. I can't say that I can make an ultimate judgment about what's best for the country with democracy. I'll just say again, I don't think the Constitution is a pro-democratic document. In fact, I didn't talk much about the founding evidence about any of these issues, but one lesson I think comes clear from the founding is that the Constitution is actually meant to reject a lot of the more extreme sort of populist measures of government, which were present in the states at the time. Professor Stephanopolous is quite right to say the Constitution actually was a work by leaders who were suspicious of state legislatures because of the unbridled democracy of it all. And if you want to talk about anti-democratic features, you should concentrate on getting rid of the Senate if you want to do anything. So my problem is, does the Constitution actually create a substantive norm that requires something along the lines of what you're talking about, David? Something like the members of a congressional delegation must mirror in some way, right, the division of partisanship within the state population. Again, that's sort of like, to me, claiming there's an objective standard of saying what does an electoral map have to be. Notice also, this only takes place once every 10 years. I mean, the state's population can radically change in a 10-year period that no longer is reflected in the districting map from, say, 7, 8, 9 years ago. Even that system would not be perfect in aligning the number of congressional, the division of the congressional delegation with the population's, the population's balance. But I think that when the founders place these responsibilities in the state legislatures, I think in a way they were not expecting the state legislatures to try to accurately reflect the wishes of the people. I think at times when you look at the different places that the Constitution locates things in the state legislatures, it's when they wanted that function to represent federalism, just to represent interests of states as institutions more strongly than perhaps what the people of that state want at that time. So yeah, I don't think the Constitution should require that there be this. I take Professor Stephanopoulos' point, though. A lot of other countries, they wouldn't do it this way, right? A lot of other countries, like a pure parliamentary system in England or in Western Europe, they would try to allocate seats fairly closely to the division in the population. We have a different system. I think our federal system, does balance things, lean things towards this kind of federal system of government because the founders were suspicious of democracy.
Professor Stephanopolous, again, I'll give you the last word before we open it to the questions and answers from the audience.
Yeah, a couple of thoughts. To some extent, we've now kind of slid into relitigating the issue in Rucho as to whether the federal Constitution directly bars partisan gerrymandering, which of course is a separate issue from the issue here, which is when a state court under a state constitution wants to do something about partisan gerrymandering, does the federal Constitution somehow step in and prevent the state court from doing something under a different body of law? So that's one point. Second point is that federalism is no help here to proponents of the ISL theory, because of course federalism, the basic pillar of federalism is that states get to decide how they're going to structure their governments and their election systems. And so proponents of the ISL theory have to take a very anti-federalism stance to say that states are not permitted to have gubernatorial vetoes. States are not permitted to have popular referenda or voter initiatives. States are not permitted to have state constitutions regulating congressional redistricting, notwithstanding the fact that we generally believe in states' autonomy to structure their political systems the way they see fit, we're going to wipe away all those federalism commitments in this particular area. I guess I'll stop there and we can throw it open to questions.
Okay, well, we have two questions from two noted contemporaries of mine. One is from David Applegate, and I'll read it. It says, I find all this discussion about the future of our democracy all too precious under a constitution that, as John Hughes says, in many respects is anti-democratic. Why is the Supreme Court seemingly so reluctant to enforce the Republican form of government clause? And then let me read the second question because I think it's related and reflects the other side of it. This is from Thomas Rosenwein. There was a second founding with the passage of the 13th, 14th, and 15th Amendments. So should we not look to those later 19th century founders? Does the privileges and immunities and equal protection provisions in the 14th Amendment mean that courts, state or federal, are authorized to intervene and protect democratic rights? John, you want to start with trying to answer those two questions?
Sure. I'll try to do a quick with the first question. I think the reason why, this is a case called, I think it's Pacific Telephone and Telegraph versus Oregon. I think the reason why the court doesn't enforce a Republican guarantee clause is the court basically can't figure out what the standards would be. Like, what does Republican form of government mean? And then it also, I think, suggested that that function is up to the other branches of the government anyway, that Congress and the president can sort of police what Republican government means. That does tie into the second point, the second question, and that certainly Congress has a power under Section 5 to enforce the 14th Amendment. I don't agree with City of Bernie and its progeny, which say basically that the court decides what the 14th Amendment substantive terms mean, and then Congress kind of enforces them. If you want to give City of Bernie that stronger reading, which I do. I do think that the Reconstruction amendments do give the other branches, but particularly Congress, this ability to decide for themselves what the Reconstruction amendments mean and then to enforce them. However, I don't think that they necessarily override federalism in every aspect. Let me put it in this hypothetical. Suppose there were a state that decided to no longer allow the selection of presidential electors by popular ballot. Suppose one state, I don't know, let's call it South Carolina or North Carolina, says the state legislature will pick the electors again, presidential electors again. I don't think the Reconstruction amendments would require a state to say, no, you must, require the courts, I'm afraid, to say, no, the states must use popular election to pick their presidential electors.
Even if those state legislatures were gerrymandered in a way that tipped the
sure.
That was racially.
Sure. And actually, there's this interesting movement afoot, right? This, I'm not sure whether it's a compact or not, but there's this thing called the National Popular Vote Initiative, which is trying to get states to agree, right, to give their electoral votes to whomever wins the national election rather than who wins, the election in their states. Would this reading of the 13th, 14th, 15th Amendments require there to be actually a national popular vote initiative? I don't think so. So I don't think that you can read out of those constitutional provisions this sort of broader sort of democracy principle that courts have to use whenever they're getting into election cases.
Okay, Nick, I want to give you a chance to respond before we have to adjourn.
Yeah, great. So what these questions make me think of is, I think, a response to Professor Yu's point that our Constitution is anti-democratic, doesn't contain a democracy principle. It's true that, compared to other constitutions, our Constitution is not as pro-democratic as it could be. Nevertheless, we have a Republican guarantee clause, which is a pretty powerful, explicit endorsement of popular sovereignty. It's true the court hasn't enforced that guarantee, but that's a separate question from whether the Constitution contains that guarantee. We have other constitutional provisions that recognize principles of equality and freedom of speech and association, which are fundamental democratic principles. We have a whole set of constitutional amendments that bar denying or abridging the right to vote on various grounds. And so again, this is not as expansive of a recognition of the franchise as I might dream of, but it's still pretty good. And so I think from the combination of the guarantee clause, the 14th Amendment, the First Amendment, the various suffrage-related amendments, it's perfectly plausible, if not actually compelled or compulsory, for a court to infer a broader pro-democratic principle from our Constitution. We know that it's plausible because the court, inferred exactly this principle for a long time. It's true the current court doesn't believe in a meta principle of democracy, but for several decades, we did have a court that believed in a meta principle of democracy flowing from our Constitution, based on exactly the language that I've just mentioned. And so I guess I'll close by just pointing out what a terrible conflict there is between the ISL theory and this constitutional meta principle of democracy, right? The outcomes of the ISL theory being enforced would be rampant partisan gerrymandering, but also much, much worse, right? If a state legislature wants to savagely restrict voting in congressional elections, that has nothing to do with gerrymandering, but the ISL theory equally applies to restrictions of voting at the congressional level. That would be in dramatic tension with any formulation of this meta principle of democracy. And yet the ISL theory would say that no, the federal courts have to stand back and permit, even mandate these kinds of voting restrictions. So I think that the ISL theory, to me, the fatal flaw with the theory is that it cannot be reconciled with the meta principle of democracy that I think does exist, even if not as fully as I would like in our Constitution.
All right, and on that note, I'm afraid we will have to leave things where they are. I want to thank both our debaters for their participation and their very interesting and thought-provoking answers. And I want to thank the ABA and the A2 ACS chapters and the Federalist Society chapter, as well as Reform for Illinois for sponsoring. For those Illinois lawyers interested in getting CLE credit, there will be an email going out to you tomorrow with instructions on how to send us the information, basically your name and your ARDC number and an affirmation that you watched the program, and we will then issue a certificate of attendance to each of you. So thanks again to everyone, and look for our next debate. I'm not sure when that will be, but this will be a continuing series of debates where we try and take these contentious issues and discuss them civilly. Thanks, everybody, again.
Thanks for having us.
Thank you.